Insolvency and Bankruptcy Code 2016 IBC. The Insolvency and Bankruptcy Code 2016 is the key law that consolidates and amends the law relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner. Objectives of the IBC: first, provide a single unified framework for insolvency and bankruptcy. Second, ensure time-bound resolution of insolvency, example 180 to 330 days or corporate cases. Third, maximize value of assets of insolvent entities. Fourth, promote entrepreneurship and availability of credit. Fifth, balance interest of stakeholders, creditors, debtors, employees, etc. Structure of the code. First, corporate insolvency resolution process. Applicable to companies and LLPs, can be initiated by financial creditors, operational creditors, the corporate debtors itself. Process includes filing application with NCLT. Second, appointment of interim resolution professional. Third, formation of committee of creditors. Fourth, preparation of resolution plan. Fifth, approval by COC 66% and NCLT. Liquidation process initiated if CIRP fails, no resolution plan is submitted, approved. Corporate debtors violates terms of approved resolution plan. Fast track CIRP for small companies or startups. Second, shorter time frame 90 days, extendable by 45 days. Fourth, insolvency of individuals and partnership firms, still under phased implementation. 2 phases, fresh start process for low income debtors. Insolvency resolution process and bankruptcy process. Fifth, pre-packed insolvency resolution process, introduced for MSMEs, micro, small and medium enterprises. Second, debtors in possession model with creditor approval, faster and more cost effective. Corporate insolvency resolution process. Let us see the process. CIRP is a process through which financially distressed companies, corporate debtors undergo insolvency resolution in a structured and time-bound manner. Time limit: standard CIRP duration 180 days, extension up to 330 days, including any litigation delays. If no resolution plan is approved in time, liquidation is initiated. Step-by-step process of CIRP. Step first, filing of application. Section 7, 9 or 10. Filed with NCLT must include evidence of default. NCLT must admit or reject application within 14 days. Step 2, commencement of CIRP. Once admitted, moratorium section 14 is declared. No lawsuits, no asset transfer, no recovery actions, no foreclosure or enforcement of security. Public announcement is made inviting claims from creditors. Appointment of interim resolution professionals IRP by NCLT. Step 3, interim resolution Professional IRP. IRP takes control of management operations, financial records, collect claims from creditors, forms the committee of creditors. Step 4. Committee of creditors formation, made up of financial creditors, voting based or debt share. COC's power: approve, replace IRP with a resolution professional, evaluate resolution plans, decide continuation on continuation or liquidation. Step 5. Resolution professional takes over the IRP, usually the same person, conducts due diligence, invites resolution plans from eligible resolution applicants. Step 6. Submission and evaluation of resolution plans. Applicants must meet eligibility under section 29A. Example: no willful defaulters. Resolution plan must provide for payment of insolvency cost, provide for repayment of operational creditors, not be prejudicial to stakeholders, be feasible and viable. Approval of resolution plan by COC requires at least 66% voting share approval. Once approved by COC, submitted to NCLT for final approval. Step 8. Implementation or liquidation. If NCLT approves resolution plan, company continues under new management. If no plan approved within deadline, liquidation process begin. If CIRP fails, liquidation process starts. Liquidator appointed, assets sold. Thanks.